The Supreme Court has agreed to take up the J6 case, which affects Trump. I'll explain it. We'll read all the articles here, and you'll have a full update and the entire plan for how the Supreme Court gets Trump off the hook. I'm Doug in Exile. This is where all the happy patriots are. Let's go. Okay, so first, here's Julie Kelly. She's a lawyer, and she writes a lot on this stuff for Washington. She has a great Substack. Holy blank, the Supreme Court will review 1512 C2 obstruction of an official proceeding case. This is a felony used against 300 of the J6ers and represents half of Jack Smith's indictment against Trump. If SCOTUS determines Department of Justice has misused the statute, it'll be a game changer. The Supreme Court to hear case that could reverse January 6 charges against hundreds, including Trump. So this is the big surprise. This is even bigger than the Supreme Court yesterday agreeing to look into the Trump immunity claim. The Supreme Court on Wednesday said it would take up an appeal by a January 6 defendant, which could result in hundreds of reverse charges from the riot at the U.S. Capitol, including former President Donald Trump. Now, Donald Trump wasn't involved in the riot, but they're saying that he tried to overturn an official proceeding of the electors and all that. So the justices will review an appeals court ruling that revived charges against 3 defendants accused of obstructing official proceedings. The charges refer to disrupting Congress's certification of President Joe Biden's 2020 electoral victory over Trump. Let's keep going here. Trump himself is facing the exact same count in special counsel Jack Smith's case, which across the 2024 Republican presidential primary leader of conspiring to subvert the 2020 election after his loss. Trump, like the January 6 defendant, is charged with conspiracy to obstruct an official proceeding. The Justice Department has brought the obstruction charge against more than 300 defendants in the sweeping federal prosecution it has pursued since the violence at the Capitol on January 6, 2021. When a riot formed at the complex of anger and frustration during Biden's election certification. So this could get a whole bunch of J6ers off, because I believe this statute was also misapplied to them as well as misapplied to Trump. We'll get into the statute in just a second. This is about an Enron statute from the early 2000s that was misapplied to this thing. If the Supreme Court sides with the defendant, Trump, the J6 defendant, and discards the obstruction charge, hundreds of other J6 defendants could appeal their convictions and shave years off their sentences. Some are facing the prospect of years and years behind bars. Justices are being asked to consider whether Section 1512 C2 of the United States Code is the right statute under which to prosecute the defendants. The original 1512 statute was to keep Enron people from encouraging others to destroy evidence that they needed for trial. So that would disrupt a court proceeding. It should not be applied to whatever Trump and the J6ers did, on J6. The Supreme Court ultimately agreed to take up the case involving defendant Joseph Fisher, who was given the same charge as 2 other defendants who petitioned the High Court, Jacob Lang and Garrett Miller. Here's back to Julie Kelly's Twitter. This is a day so many J6ers have been waiting for. Lives destroyed, people rotting in prison, all because Biden's Department of Justice abused a post-Enron evidence tampering statute. She writes, and what will Jack Smith do now? 2 of the 4 counts in his indictment is in jeopardy. This is potentially more impactful than the immunity issue. This is the immunity issue we talked about in yesterday's video. Make sure you subscribe so you don't miss these videos. Will he drop the 1512 C2 related counts? Will Jack seek a superseding indictment with other charges? Trump's lawyers presumably will file a motion to dismiss those counts. And then finally, this is her last update I just got. As I reported several days ago, as we awaited SCOTUS Supreme Court decision on 1512, this represents a collision course with Jack Smith. SCOTUS likely will hear oral arguments in March or April, the same time Trump is on trial for the same charge. If March 4th trial date sticks, which seems impossible now, so it's going to push But let's say it sticks and Trump is convicted by a DC jury, Jack Smith's DC Democrat jury. Then the Supreme Court comes down with a decision in June that reverses how Department of Justice and Jack Smith interpreted 1512C2. The same month, Judge Chutkan would be prepared to sentence Trump, and it'll get pulled out from under her too. All this stuff has the possibility of going away, and this is something that Fani Willis, Jack Smith, Chutkan, all the bad guys had no idea would happen as of today. We had no imagination because they had turned down this J6, looking at this J6 case, and now they're going, you know what, we got to take it out. And I hope they get sprung. I hope they also reverse the Trump charges and end all this madness. I'm Doug in Exile.